happened before. Learned Counsel, Mr. Madenge, took the view that the text of the 2010 Constitution in fact supports the basic structure doctrine because the Constitution has a core content and contains fundamental prior principles that are immutable in. Making reply to all that, Mr. Nyamori contended that the basic structure and the basic structure doctrine are not synonymous. The former refers to fundamental entrenched provisions which the Constitution contains, while the latter restricts amendability of the Constitution, a notion he rejects, as all provisions, according to him, are amendable, albeit by use of a different procedure where entrenched provisions are concerned. Finally, he considered that Professor Rosnai is undoubtedly an authority on the basic structure doctrine, but invited us to find that the intensity of judicial review of proposed amendments depends on the amendment process involved. Mr. Donald Kipkorir, Learned Counsel, maintained that the basic structure doctrine was inapplicable in Kenya. And he seemed to suggest that it would be archaic and anachronistic to insist on a phenomenon from classical Greece where constituent power was exercised directly. Professor Mugai, Senior Counsel, in reply, labeled this a case about theory and not a live one about live people. He repudiated the idea that a constituent assembly is any more effective an exercise of power and authority than the people's exercise of sovereign power to effect or ratify radical changes to the Constitution at a referendum. He urged that the BBI Amendment Bill was not trying to reenact the Constitution because it left 90% of it intact. I have taken the trouble to set out only the oral submissions made on this fundamental issue of great significance, even though I have painstakingly read and pondered over the copious written submissions filed, as well as the numerous authorities cited. Before I go into a detailed analysis of the arguments, I'm skipping quite a bit because of time. Before I go into a detailed analysis of the arguments and specifically the case law and academic writings presented to support the rival positions, I must confess that hearing the positions taken by some of the parties before us had an air of the surreal about them. Some counsel spoke of the basic structure doctrine as if it was a novel and unheard of idea that had just set foot on our jurisprudential shores for the very first time. It was projected as a thing of pure theory, a hypothetical chimera, never before applied to real situations. Moreover, the manner in which this country's long and painful search for a new constitution was projected by opposing parties speak differently to different readers. But counsel should nevertheless endeavor to apply their best mind to extract the true meaning of the constitutional text as well as the judgments and academic writings on a subject. Only then can they be truly said to have assisted the court and shown themselves honest guides as required of advocacy at the bar. I do not consider it necessary to go into do a detailed history of the making of the 2010 Constitution. Suffice it to say that its promulgation, which is seen as the birth of the Second Republic, was the culmination of many years of struggle and pain, sweat and tears, in which liberty, limb and life were harmed and lost so that Kenyans could have a better life of freedom and dignity, and in particular, that they could have a government that is answerable to them and leaders who serve them, not lord it over them. The Constitution is a charter of liberty, the embodiment of a new deal, and a break from a past characterized by oppression and oppression of freedoms as simple and essential as expression, association, and assembly. The one-party state, first de facto, and then by the instrumentality of the rushed amendment that brought in the infamous Section 2A of the retired Constitution, installing the Kenya African National Union as the sole political party de jure, brooked no opposition. Treason, sedition, public order, foreign exchange restrictions, and a motley other laws were used to beat the populace into submission. Detention without trial, torture, prosecutions on trumped-up charges, confiscation of passports, and many other misdeeds marked the darkest days of independent Kenya. The spirit of our nation is a resilient one, however, and buoyed by and inspired by happenings elsewhere, including the collapse of the Berlin Wall and the reforms occurring in the former Soviet Union through the policies of glasnost and perestroika, there was sustained agitation for more democratic space. In time, Section 2A was repealed, reintroducing multipartyism, and through false starts and faltering steps, the new constitution was born. It was the product of phenomenal public participation and driven by bold Kenyans represented as the ordinary Wanjiku, who might as well have been Auma, Amina, Chela, Mwende, or Mora, and all of their male equivalents. Kenyans gave their views on what ailed their land and their institutions of governmental power. Their cry was for more equitable share of resources, and ensure that their voices were heard before they declared in a detailed preamble that they were, among other things, honoring those who heroically struggled to bring freedom and justice, proud of our diversity, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law, and exercising their sovereign and inalienable right to determine the form of government of our country, and having participated fully in the making of the Constitution. To my mind, this preamble provides the context and setting, the background and canvas against which an analysis or interpretation of the Constitution must be undertaken. The Constitution was not the product of an immaculate conception. Rather, it was the product of a rich experiential milieu of legal, social, and political interaction, more particularly captured in numerous historical accounts of trial and ultimate triumph, including the final reports of the Constitution Review Committee and the Committee of Experts. Any court interpreting the Constitution must perforce be alive to the historical background if it is to do justice to the text of the Constitution. Anything short of that would be drab, dry, and skeletal at best, lacking the pulsating animation of a living document possessed of a spirit and an ethos. Indeed, as if fully aware of the easy slide to dry formalism in construction and obsession with text and lexical renderings, oblivious to history and context, the Constitution itself provided the keys to its construction in explicit terms in Article 251(1), which is that it must be interpreted in a manner that promotes its purposes, values, and principles, that advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, that contributes to good governance, and every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking. It seems to me plain beyond argument that filter to the constitutional text itself throws open the pathways of interpretation to the end that one must look at what the Constitution provides in a manner that is wide and imaginative, so that it should be given the fullest amplitude of meaning and intent. The interpreter must have the purposes, values, and principles of the Constitution ever in mind as he undertakes the task. What is called for is purposive, value-laden, and principled approach to constitutional interpretation, as opposed to a narrow, neutral, and ultimately neutered formalism. Moreover, those charged with interpreting and giving effect to the Constitution cannot shut their eyes to, or be indifferent to, or worse, evince a hostility towards the rule of law, human rights and fundamental freedoms. The Constitution commands judges to be active participants in those causes, and it behoves us to constantly introspect and deliberately push forward the rule of law and the human rights project. It will be a serious dereliction of duty, productive of deleterious effects, were those charged with the solemn duty of advancing these causes to be found wanting through carelessness or inattention, thereby either stalling or reversing them. To me, stringent urgings for judicial restraint where the rule of law is under threat and human rights are abused are totally antithetical and anathema to the plain constitutional interdict. Where these matters are concerned, fealty to the judicial oath demands, nay, commands, conscious activism. We do not become judges to subvert the plain and uncompromising edict to advance the rule of law and human rights. To my mind, that the Constitution very deliberately calls me to be a warrior for the rule of law and human rights and to be both faithful and fearless in the cause is beyond question. Precisely because the law, as with life, is not static, the Constitution calls upon those who interpret it to do so in a manner that permits the development of the law. This is an acknowledgement that our knowledge of law is not at its zenith, and none can boast of having attained the acme of legal omniscience. This is where we are called upon to be open-minded, even to those concepts that may at first blush seem strange or challenge our long-held beliefs. We live in a globalized world, and courts will always be part of a continuing conversation on comparative constitutional law and practice. We are part of a global community of courts, and we definitely can and do benefit from a cross-pollination of ideas. We receive and consider those that have migrated to us, being careful to accept and incorporate those that can be said to be markers of positive development, even as we should think that our own progressive jurisprudence is solid enough and sufficiently persuasive to other jurisdictions. That, to me, is the constitutionally ordained interpretative prism and lens through which I must approach and decide the applicability of the basic structure doctrine to our Constitution. I proceed from the appreciation that the Constitution is laden with normative fecundity, which should vivify all persons who are charged with its application or interpretation. I mentioned some provisions, and I say those provisions are couched in plain and peremptory terms, requiring no further position. I need only state that the obvious fact that this obligation, unquestionably binding as it stands, takes on a more solemn aspect, sacred even, in the case of those who occupy certain state offices by first swearing allegiance to the Constitution. Such oaths are of the gravest import and not to be lightly taken or regarded as mere formal incantations, empty rituals bereft of meaning or substance to be violated with no consequence. Those who swear by the Constitution must be prepared to live by it and defend it as commanded, or else give the officers that come with such burdensome demands on their loyalties and consciences a wide berth. It should be plain by now that the approach to constitutional interpretation that persuades, indeed binds me, is a purposive and holistic one, which repudiates the text as the alpha and omega on the divination of the meaning and intent of the Constitution. One needs only cast a glance at our history of constitutional jurisprudence to see the long shadow cast by a textualist obsession as exemplified in Republic versus Elman back in 1969. That approach, thankfully long interred, although every once in a while we hear its ghost clanging its chains, seeking a place at the interpretative table, declared that the Constitution was to be interpreted in the same way as any other statute and frowned upon any resort to the spirit of the Constitution in derisive and almost epithetical terms. The fortunes of Elman doctrine have been traced in Mudhomi Thiankolu's landmarks from Elman to the Saitoti ruling, searching for philosophy of constitutional interpretation in Kenya. It is no wonder that for long periods of Kenya's post-independence history, constitutional guarantees of freedom and fundamental rights remained for the large part, mere pious platitudes. And I see this as an object lesson for those of us on whom falls the obligation to give meaning to what the Constitution provides. We must learn from the mistakes of history, lest we be doomed to repeat them. It only takes a restrictive, minimalist interpretation here and a textualist, formalist approach there for the spirit of the Constitution to be stymied and its lofty ideals to hemorrhage towards barrenness by a drip drop of near imperceptible clawbacks and innocuous-seeming small steps of mark time, slide, and reverse. And I need only add that the Supreme Court has recognized that the 2010 Constitution is a transformative charter to be understood and interpreted as such. In much the same way as new wine cannot be stored in old wineskins, it would be totally illogical to try and squeeze a transformative constitution within the suffocating straitjacket strictures of formalistic or positivistic interpretation. I have no difficulty whatsoever following the fresh and expansive interpretive path blessed for us by the Apex Court in several pronouncements. I've quoted them. I've quoted the Supreme Court in the Interim Independent Electoral Commission case. And then in the matter of the Speaker of the Senate, the Supreme Court characterized the 2010 Constitution as having gone beyond the usual parameters of liberal constitutions with its deliberate aim of attaining social change and reform as spelled out in the preamble, part of which I have already adverted to. The aim of that transformative approach is to recognize and reset the interplay of majoritarian and non-majoritarian institutions of the state so as to reach the desired governance goals. It is not difficult to see that such a constitution can ill afford a mean-spirited and narrow-minded interpretive approach, as that would totally negate and defeat its transformative aims of facilitating the socio-economic and political growth of the country. This is identified in the Supreme Court Act, but flows from the Constitution itself and must guide all courts in interpreting the Constitution. I have agreed with the words of Chief Justice Emeritus Mutunga in the Speaker of the Senate and another versus the Attorney General. Only to take perhaps one sentence from there, it is in this context that the spirit of the Constitution has to be invoked by the court as the searchlight for legal illumination and elimination of these legal penumbras. From my analysis of their judgment, the learned judges were faithful to an interpretative scheme that was holistic, cognizant of the transformative character of the 2010 Constitution, purposive, and properly contextual. That approach accords with my own understanding of what the mental orientation of a court undertaking interpretation of our Constitution ought to be, and I would accordingly reject the criticism leveled against the learned judges. I do not accept the attempted denigration of their acknowledgement of the spirit of the Constitution, as if recognition of the spirit of the Constitution was some spiritist, animist retreat to a dark and ignorant or superstitious past. To the contrary, every legal instrument does have a spirit and soul that animates it. The learned authors of Black's Law Dictionary, 11th edition, trace it back to 1802, more than 2 centuries ago, and explain that it is also termed as the spirit of the law and means, quote, the putative intention of the creator or creators of a legal instrument as opposed to its literal content. This is to be contradistinguished from the letter of the law. And they also treat of the spirit of a letter conception, which is of much recent birth, born in 2014, which they define as, quote, the notion that the spirit of the legal text should prevail over the letter. As far as the spirit of the Constitution is concerned, we endorsed it in the case of the Independent Electoral Boundaries Commission versus Menacare and others way back in 2017, where among other things we said the constitution of a nation is not simply a statute which mechanically defines the structures of government. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values binding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. I believe in those words we were quoting the Supreme Court in the matter of the Interim Independent Electoral Commission. We dare say that in the context of the Constitution, there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Now, does the basic structure doctrine apply to the Constitution of Kenya 2010, thereby limiting its amendability? The learned judges went through 50 paragraphs of more than 20 pages of history. I do not wish to repeat that history. I've already given I've given a brief overview of the same, but some of the high points or low points include the CKRC draft constitution, the general, the post-election violence of 07, agenda 4, etc., etc. The High Court's engagement with the basic structure doctrine was with that history firmly in view. The case made before them was that the 2010 Constitution contains essential features and critical characters and fundamental values that enjoy transcendental existence, whose derogation is not contemplated in the Constitution by way of constitutional amendments. It thus forms eternity clauses of unamendable provisions. Upon intense analysis, the learned judges pegged their conclusions partly on the people's demand for and insistence upon the direct involvement through conscious and informed participation in the constitution-making process, and I have quoted them. Indubitably, the people were not mere observers or peripheral players in the making of the 2010 Constitution. They were wielders and shapers of destiny, not mere instrumentalities for the formal adoption of a document conceived, gestated, and birthed by the political power elites of the day, only for them to attend and vote at a referendum that would be no more than a ritual naming of a product not their own. The recorded history is crystal clear that the people of Kenya conceived, composed, and constituted their constitution, which they birthed in 2010. And it is only natural, in the way of the Swahili saying, uchungu wa mwana aujuaye ni mzazi, it's the mother who knows the pain of childbirth, as contrasted with my native Kisi saying that mwana wandima mire makendu, another's child is but cold phlegm, that the people of Kenya were very particular that the child of their own making, in which resided their hopes, dreams, and aspirations, as well as a clear statement and architecture of how they wish to be governed, should not suffer the fate of the previous constitution. That other had been amended many times in a deliberate and systematic scheme to quarter it, water it down, dismember, and all but obliterate the promise of freedom for the citizens and limited government that it once had. They expressed their views to CKRC, which I have quoted, and the concerns about constitutional dilution, abrogation, or capture through amendments were also captured. Indeed, they said, considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new Constitution from a similar fate? I'm quoting from the CKRC report. And then they also asked, how can we prevent the decay of constitutional institutions and state organs, as has happened with the institutions of the present Constitution, the past Constitution? Now, it is a sad blight on Africa's post-independent experience that no sooner did the nations gain independence than the power elites embarked on diluting and dissolving all restraints on power and authority, a blurring and final obliteration of checks and balances, and a concentration of power in the presidency. They did this principally through facially legal and constitutionally compliant changes to their constitutions. I have immersed myself in the writings of Professor Nabueze relevant to this subject and taken account of his description in excruciating detail and depressing detail of the manner in which power became so concentrated in the hands of the founding fathers, the heroes of independence, to the detriment of good governance and the rule of law and the liberty of citizens. In Presidentialism in Commonwealth Africa, for instance, he dedicates chapter 5, Office of the President, and starts off under the head, The Extent and Reality of Presidential Power, by pointing out that the most striking feature of the presidency in Africa is its tremendous powers. He goes on to state, which I consider germane to quote in extenso for a full appreciation of the reality that informed Kenya's search for a new constitutional paradigm. He said many things, but just one sentence I will quote there. The Africanness of the presidency in Africa refers to the fact that it is largely free from such limiting constitutional devices, particularly those of a rigid separation of powers and federalism. Now, he talks about aggregation of power, concentration, etc. So, that aggregation and concentration of power, with the attendant creation of imperial presidency, was achieved mainly by constitutional amendments. To achieve them, the restrictions to the amending powers built into the independence constitutions were assaulted and successfully abolished or attenuated. Ghana, the first country to attain independence in 1957, was quick to abolish all the restrictions to amendability, even and especially of entrenched provisions the very next year by the Constitutional Repeal of Restrictions Act of 1958, which was passed strictly in accordance with the prescribed procedure. Thereafter, a simple majority sufficed for every constitutional amendment. The proponents of the abolition of restrictions to the amendment power, including Nkrumah himself, castigated them as a colonialist imposition, an affront to the sovereignty of the new state, and a perversion of the democratic state. I must confess, it did give me an uneasy sense of deja vu when I heard similar arguments made before us in condemnation of the learned judges for deigning to find that there is a limitation to amendment of the 2010 Constitution. Noboza then recounts the Kenyan experience under which the provisions relating to entrenchment and thus restriction of amendment power were systematically removed or watered down. I believe this particular part was also quoted by my learned brother, Mr. Justice Gatembu. I will not go over it again. After detailing the same trend in Uganda, Tanzania, Malawi, and Zambia, the author observed quite correctly, in my view, that whereas amendments per se may not be objectionable, quote, too frequent amendments may tend to reduce the Constitution to the level of an ordinary law, depriving it of any claim to respectability and devotion, which might in time earn for it a status akin to sanctity. Kenyans were keen to ensure that the 2010 Constitution did not suffer the same ignominious fate as its predecessors, and they told the CKRC that its amendment had to be restricted. And I have quoted the report on what the people said and the commentary by CKRC, where indeed they concluded the people therefore wanted a fairly rigid arrangement, the amendment of which would require their participation in some form. In their view, the new constitution should only be amended in the same way in which it is made. I have laid emphasis on the last part of the commentary because, to my mind, the people of Kenya were quite clear that they were not going to cede the constitution to the vicissitudes and vagaries of political expediency. Having birthed it, they were prepared to nurture it and protect it from mutilation or dismemberment. They desired to be involved in its fate and fortune, and were essentially saying that only as they made it could it be substantively altered with their full and informed participation. It is clear to see, therefore, that the people, as creators of the Constitution, were exercising a power that was without and above the Constitution. They could not have been creating it pursuant to any of its provisions for the rather commonsensical reason that it was not existing at the time, not having been constituted. The power to constitute a constitution predates the Constitution, and it is with great respect quite absurd to seek constituent power within the Constitution. The power is original, a priori, primordial, and is inherent in the sovereignty of the people. It is not subject to the Constitution, which is but an emanation of it. This is the constituent power with which the people themselves, acting directly, can both make and replace our Constitution. I've quoted Nabweze. The Njoya decision, which Ringera actually quotes Nabweze, was never appealed against and has remained the law on this subject, followed and reaffirmed on many occasions over the last 15 years. I have gone over Ringera's judgment, Ringera J's ruminations on the subject of constituent power, its being an expression of the sovereignty of the people, its existence outside the Constitution, yet having implicit recognition in it with a cognizable juridical status. Having done so, I think I can do no better than set out at some length what he had to say, with which I fully concur and apply mutatis mutandis to the 2010 Constitution, but because of time, I will not read all of this stuff that he said. The relevance of the constituent power to a discussion of the basic structure doctrine is that it is presented as the only authority that can effect a legitimate alteration to an aspect of the Constitution that lies at its core or relates to its essential character. The argument is that amendments or alterations of that kind are not amendments properly so called, but have the effect of abrogating it or destroying the very foundations or pillars upon which it rests. I've quoted John Rawls in Political Liberalism, where he gives an example of whether the Americans could decide and amend the first Constitution. The First Amendment